In February's AILA interview of the month, AILA past president Chuck Kuck shares details of the Georgia lawsuit he has led, pushing for DACA recipients' rights to in-state tuition. Where do things stand?
Well, on December 30th of last year, the judge issued her decision saying DACA students were entitled to in-state tuition under the rather bizarre rules written by our Board of Regents, which said that in-state tuition, besides all the other criteria you need to meet, can only be given to people who are lawfully present in the state. Okay, as any immigration lawyer knows, DACA kids are lawfully present. And yet through the previous litigation, which we took all the way to the Georgia Supreme Court and lost on the ancient legal theory of sovereign immunity, when we came back, we filed a mandamus action against each individual member of the board. And the judge that was assigned to us at the Superior Court level said, absolutely perfectly good to do that. And by the way, lawful presence means whatever the federal government says it means, these kids should get in-state tuition. So from that point, the State Board of Regents did not immediately agree. There's a weird rule about a stay here, which may or may not have been in effect, but effectively was in effect. And the Attorney General filed an appeal with the Court of Appeals. Now, oddly enough, on January 1, 2017, a new law went into effect. And prior to that date, if they'd appealed prior to that date, they would have appealed directly to the Supreme Court. But the rule changed. Now you appeal these to the Court of Appeals. So they appealed to the Court of Appeals, and they asked for a stay. And over my objection, they gave them what's called a supersedious or a stay. Now here's where it gets better. The Court of Appeals, looking at the case, realized there's a federal legal issue involved here and said, oh, wait a second, preemption? We can't handle that, and sent the case to the Supreme Court. So we're actually back at the Georgia Supreme Court, where I hoped we would be right away, and we're waiting to hear from the Supreme Court about whether they will take our case on an expedited appeal so that we can then hopefully get a decision from the Supreme Court before this semester is over. And that's why if we do win, and I believe we will win, these kids can then get in-state tuition next semester.
Why did you take this case?
You know, people ask me that, and the answer is simple, and I think any immigration lawyer would agree with this, because it's the right thing to do. It is inherently unfair. It is immoral to tell a kid that he can't go to college if he can't afford to do that. It's just immoral. I mean, I know Bernie ran on this, and I'm certainly no Bernie fan, as all my friends know. But Bernie was right about this. If you want an education, you should be able to get an education at an affordable rate. And to tell these kids who grew up here, who have been paying taxes legally in Georgia because they've had work permits for the last 4.5 years, oh, you can't pay in-state tuition because why? Because of a piece of paper about where you were born? That's just immoral. And I took this because, frankly, I was pissed off. And it was the right thing to do. And these kids asked me to do it. I said, absolutely, we'll do that. We've done it pro bono since the beginning. I doubt we'll ever get any fees from the government. But I don't care. I don't even keep track of my time. I just want to win this case for these kids because it will change their lives. And that's what we're in the business of as immigration lawyers, is changing lives.
How can members in other states replicate this?
Well, here's what's interesting. For example, in North Carolina, their Board of Regents has a similar policy with the exact same words, lawful presence. Why aren't they suing? There are other states where you have to look at what the board, whatever their equivalent to the Board of Regents is. What is their policy on in-state tuition? We are litigators. We're lawyers. We can go to court, and we don't have to be limited to the court that we normally appear in immigration court. We can go to real courts and bring real lawsuits that make real differences in many people's lives. So my message to my colleagues out there in the immigration bar, step outside the immigration penumbra for a minute. Look at what your clients really need in their lives. If you live in a state that is denying in-state tuition to DACA kids, find out why, see if there's a good argument under the law why they're wrong about that, and file a lawsuit. It's fun to sue the government, whether it's the feds or the states.
Thanks, Chuck, for joining us.